Welcome to Law Line. I'm Mark Proctor. I'm your host for today's Law Line show. And Law Line is a legal topic show brought to you by the members of the law firm of Levin, Papantonio, Thomas, Mitchell, Rafferty, and Proctor. We, the lawyers of the law firm, appear here on Blab TV to do our show to discuss different legal topics of interest and different topics in the course of our ever-changing law. Today, we're going to discuss a very, very important topic that has affected all of our communities and our very lives, and that's the topic of the BP oil spill and its effect on all of us. So I want you to get comfortable. We're going to talk to you about the spill and the state of the law and what's going on in BP litigation, because this is a topic that literally affects many, many of us in our communities along the Gulf Coast, and certainly here in Pensacola and in the Panhandle of Florida. With me today, I have a special guest, my friend and law partner, Brian Barr. Brian, welcome.
Thank you, Mark.
Brian is a very special person when it comes to BP litigation. As you may know, our law firm, the Levin Papantonio law firm, was selected as one of the 4 firms to lead the national BP litigation. Brian is one of the 4 lawyers who is actually leading the litigation. Brian has been living and working in New Orleans since this spill, and he and his colleagues on the Plaintiff Steering Committee of the multi-district litigation in Louisiana have done a tremendous, tremendous job at not only preparing the litigation, but also negotiating a class action settlement that you'll recall was announced in early March and has just been filed with the federal court judge, Judge Barbier, in Louisiana. We're going to talk today about the MDL, the multi-district litigation, its role in this tragic oil spill, the state of the law, and then what has happened recently in terms of the settlement and what that settlement may mean to you. So we've got a lot of information that we want to talk about today, and we're going to go through it very carefully because, as I stated before, this is a topic of utmost importance to you and to everybody along the Gulf Coast of the United States. Brian, we know, we've all heard by reading in the paper and the many news accounts about this MDL and how it works with regard to the oil spill. But explain to our viewers what happens in a big project like BP where the effects cover so many people. How does the court system deal with this?
Yeah, the way that's dealt with in the court system nowadays is we have a process called multi-district litigation. And what happens is one of the parties or all of the parties petition the court to establish one central court to decide common issues for the entire group of people that have been impacted. In that situation, in particular to the BP situation, that motion was filed and many different places were argued for. And the panel decided that the best place that was the most convenient for all of the parties to run this litigation was the federal court in New Orleans, the Eastern District of Louisiana, headed by Judge Barbier. So that's where it was all sent. So every case that comes into federal court then gets transferred to the New Orleans court for pretrial proceedings, where we do all of the common discovery, we take all the depositions of the BP witnesses, we do all the expert discovery, and that at some point when individual cases are fully worked up and ready, they're remanded back to their local courts. And so that's kind of how that process is done generally. Now, there were some very specific things in the BP litigation because tied to that we also had a limitation trial, which was tied to Transocean, which is what allowed us to get a very early trial date. It was less than 2 years from the date of the explosion of the Deepwater Horizon rig. And we used that limitation trial date to conduct all of the discovery we needed to conduct against BP. In a matter of 12 months, we took 350 depositions, and we were ready to go to trial in the end of February. And the court had all intention of going to trial. But over that same period, while we were conducting all that discovery, we also had a team working on settlement negotiations. And as everybody knows that does what we do, the closer you get to the courthouse doors, the more willing a defendant is to settle. And BP absolutely did not want this case to go to trial. And that's what allowed us to leverage that into what we believe is a settlement process that will fully and fairly compensate all people.
And we're going to talk about that process in just a minute and spend most of the show talking about the process. But in reading the newspaper accounts, we've heard about terms like the Plaintiff Steering Committee, and when I introduced you as a member of the Executive Committee. What's the importance of that position vis-a-vis the litigation?
Well, that position, as it comes to this litigation, I mean, there were over 100,000 claims filed in the MDL, which, a lot of those people had lawyers, and that's a lot of lawyers. And any time you have that many lawyers, you can't get any work done if everybody was allowed to do their own thing. So what the court does is it appoints a steering committee to direct the litigation. I think, last count, there are 19 of us on the Plaintiff Steering Committee, and then we have 4 people that are in charge of kind of directing the steering committee. That's the Executive Committee, of which I'm a part of, and then we have our 2 leaders who are the liaison counsel that are Steve Herman and Jim Roy in New Orleans. And that's kind of the structure of how things are put together, and it's done so that we can go forward in an organized fashion with a unified strategy.
So you and your role on the Executive Committee, led by the lead counsel and the liaison counsel, are actually, from the plaintiff's standpoint, those people damaged by the spill running the litigation.
That's true. Right? Yeah, and there was actually a steering committee of defense lawyers that direct it from the BP side. Now they aren't so much appointed by the court because the defendants are able to go out and hire their own counsel. But we set up a liaison counsel for the defendants because there were so many of them that had responsibility in this spill.
Okay. Now we've heard about the again in news reports about the applicable law. We've heard the term Federal Oil Pollution Act and state law claims, and you've talked about the transocean claims and maritime claims. Tell our viewers a little bit about what laws deal with this topic and whether people have their own individual claims for their economic losses under the law.
Well, people certainly have their own individual claims under the law. The original complaints that were filed in the litigation primarily alleged causes of action under the Oil Pollution Act, under general maritime law, and under various state common laws. At the end of the day, the court did motions to dismiss on that, and what we were left with were the Oil Pollution Act claims and the general maritime law claims. For a general maritime law claim, you have to have what's called Robbins Dry Dock standing, which means you actually have to have owned an interest that was impacted by oil. So that's a smaller group of people that have that claim. That's your commercial fishermen, your property owners that had their property oiled. The vast majority of people are going to fall under the Oil Pollution Act, which does not require Robbins Dry Dock standing. It just requires a loss of profits, a loss of subsistence use for governments, a loss of revenue from their typical tax streams, that type of thing. That's all covered under the Oil Pollution Act, which is where the vast majority of people fall. Now, in context of that, I think a lot of people have heard something about the idea of presentment, which is a unique aspect of the Oil Pollution Act, where you have to present your claim to BP, and then they have 90 days to either pay or do whatever they want to do before you're able to file a lawsuit. We worked through all that on the MDL, and one of the things about this class settlement is anybody that files a claim in this class settlement meets presentment. Even if they opt out later, their presentment will have been met for them, and that's one of the very unique things we were able to get done with the settlement.
Good. Now, you talked about a trial. Judge Barbier, the federal judge, had set a trial in this matter, I believe, to begin the end of February, and at some point in time last fall, as the pressure began building up, as you said, some settlement discussions started. Tell us about when they started and how long things went on and what's happened.
Well, the settlement discussions went on pretty consistently for 8 months, that was there were a lot of different types of claims we were trying to negotiate, and we finally got to a point. The trial was supposed to start, I should say, in February 27th is when we were supposed to start. And we were really coming up against that trial date, and we felt like we had the framework of a good agreement. After 8 months of work, I mean, really for a lot of people, 15, 16-hour days for a long period of time, going from city to city and conducting negotiations, and at the same time continuing our discovery efforts and depositions. So it really was a very unique logistical challenge that to the credit of this steering committee, we were able to pull off and go toe-to-toe with BP, and in my view, not just go toe-to-toe with them, but they were chasing us more than we were chasing them, which is not how it's typically done with something like this. But as we came up on that trial date, we felt like we had the framework of a good settlement, and the court was aware of that. And that's why at that time the court put the trial off for a week to see if we could get any closer. And we got to a point where we had an agreement in principle that was entered the beginning of March, and then the court gave us 45 days to finalize that. And that's what got filed last week, was the final settlement agreement, getting it on paper, and that was the culmination of really not just the 8 months of negotiation work, but the 18 months of litigation, because the settlement doesn't happen without the litigation and the depositions and the fear of trial. And that's one of the things that, as a steering committee member, we're most proud of. Everybody told us, there were a lot of critics while we were conducting the litigation that were running around and saying, look, do you guys really want to create another Exxon Valdez? Do you really want to have 20 to 25 years of litigation? Because that's what you're running into when you go this route. Maybe you should just accept whatever the Gulf Coast Claims Facility is offering you and have it done with, because at least it's certainty and you get your money now. And we told people not to do that. We said, look, this isn't going to be an Exxon Valdez. We have a strategy in place. We believe it's going to provide a good result. And in less than 2 years from the explosion of the Deepwater Horizon, we filed a settlement agreement with the court, which is unprecedented.
It's unheard of. I mean, our firm has been involved in litigating not only these big environmental cases for many, many years, but these big mass tort projects, whether they be pharmaceutical cases or medical device cases, and it's absolutely unheard of to get a case to trial this quickly, and it's a real tribute to your effort, and it makes a tremendous difference. Brian hit the nail exactly on the head. It's trials that settle cases. The pressure of taking a big company, a big corporation like BP to trial, and then having its fate be determined, in this case by Judge Barbier in the first trial, or in many cases by a jury, that builds up that pressure cooker to the point that there's a desire to sit down and figure a way out to settle. And so you deserve all the credit in the world, you and the members of the executive committee and the plaintiff steering committee, for moving this thing along so quickly. One of the things, I'm heavily involved here in handling BP cases, and one of the things that we hear so much about from people who have been horribly damaged by this spill is, how long am I going to have to wait? Is this litigation going to go on forever? Am I going to be able to hold out, or am I going to lose everything that I've got? And you guys and ladies did a remarkable job in moving this thing along as quickly as you did to get to the point that, we've got a settlement. We're going to talk about it. I did want to mention one thing, or ask you one question before we get to the settlement. You mentioned the term Gulf Coast Claims Facility, and we know, because we read in the paper, and many of us were involved in that process by making claims and trying to get paid, that process was ongoing while you guys were doing your thing. Is what you were involved in separate or part of the Gulf Coast Claims Facility thing?
It's separate from it. And, you know, the Gulf Coast Claims Facility had a very difficult job.
They do.
They were required to put together a settlement package with a client telling them, in my view, what they could or couldn't do. And it wasn't an easy thing that they were trying to do. So I'm not highly critical of them. But I do believe with the way we got it done, which is sitting across the table from BP in a real negotiation, you're able to get a better result. And that's just the nature of litigation. So I'm not trying to be critical of the GCCF. But what I would say, I mean, we are separate from them.
Okay.
And this process actually closed the GCCF. And now we have a transition process in place that people can continue to file their claim in. And their claim will be evaluated under typical GCCF rules. And if they give them a final offer, they will have the option of taking 60% of that final offer and then waiting to see how their claim is calculated under the new process. But the Gulf Coast Claims Facility is effectively closed, and there will be a new, what we're calling court-supervised settlement program up and running, based out of New Orleans, supervised by the court within 30 days of preliminary approval of the settlement.
Good, good. And so from this point forward, then, people desiring to settle their case, to process settlements, go through this Louisiana proceeding, no more of the Gulf Coast Claims Facility.
That's correct.
Now, let me ask you this. This settlement has been described as a class action settlement, and you said earlier that under the Oil Pollution Act and maritime claims that everybody, every business has their own individual claim. How does that dovetail with this being a class action settlement? Tell us what that means.
Well, and we have put together a class settlement that applies to a class of people that essentially runs to businesses and individuals in 4 coastal counties in Texas, the state of Louisiana, the state of Mississippi, the state of Alabama, the Florida Panhandle, and the western coast of Florida, the specific counties down to Monroe County, including the Keys. That is our class of people. And then there are also people included to the extent they fish in what we call specified Gulf waters, which are the fishable waters of the United States where you're allowed to fish, including little areas, something I learned about, called donut holes, which is area shared with Mexico. That's included in the class. So that's the group of people. And what we have done is divided up the class into compensation categories. You have economic loss categories, you have VU payments, you have coastal real property damage, wetlands real property damage, real estate, sales losses, and the seafood compensation program. Those are the primary areas. It's an uncapped fund, except for the seafood compensation program, which I can explain how that was done. But everything else is completely uncapped. And what we have come up with are methodologies on how to calculate your claim. So there will now be transparent rules in place where people can see this is how a claim is calculated, and they will actually understand how their settlement number was derived, rather than it being done behind some closed curtain where you don't know and nobody can explain to you how the number was come up with. And so that's what we've put together, and it's a process. These aren't one-size-fits-all formulas. That's the most important thing, because we understood that different businesses have different models and different business plans, and you can't fit them all into one square hole. So we set up a general framework and gave people options and choices on how they calculate their 2010 claims, and then divided up the coast into zones A, B, C, and D, which we can show everybody. And those zones have importance when it comes to what we call causation presumptions, which is showing that your loss was caused by the spill, and what we call an RTP, a risk transfer premium, which think of it as a multiplier. And that's the number you multiply your 2010 losses by to come up with your total compensation amount. So that's what we've done under the class settlement, and there will be a very extensive notice program that's going to go out informing people of the details of the settlement, and then people will be able to look at the documents, figure out what their claim is, and decide if this settlement works for them. If they don't think it works for them, they can always opt out. The date for that is October 1, that people can opt out if they don't think this works for them, and they can proceed with their claim in court if that's the direction they want to go.
Let me try to dismiss a couple of myths here early. Our viewers have read the newspapers, and when the settlement was announced, you saw BP officials quoted as saying this was a $7.85 billion settlement, and you've just said that there's not a cap or a limit on the settlement. How does that work?
Well, BP is required under security laws in London to monetize any settlement they come up with. So what they've done is they've run numbers, however, and look, I don't know how they've run the numbers, but they feel like the settlement is estimated at whatever number they feel like it is. But the bottom line for our purposes is we don't frankly care what BP has valued the settlement at. All we were trying to do was come up with a compensation system that we thought was fair for everybody, and it pays what it pays. If it pays $5 billion, if it pays $15, $20 billion, BP has to pay it. And that was the important aspect of what we thought the negotiation should be. Instead of saying, here's a pot of money, how do you allocate it out? We said, here's how you allocate it. Who cares how big the pot of money is? And another myth along with that, because some people hear those numbers, a lot of people say, well, it sounds like this settlement is less than, the $20 billion that was put aside.
Right.
Well, a lot of people don't understand what that $20 billion was for. I've heard commentary of, the GCCF paid $6 billion, so there should be $14 billion left, and BP saying y'all settled for just south of $8 billion. Well, that $20 billion fund was never intended to be awarded just to people that suffered losses. It was to pay governments for their losses. It was to pay the cost of the cleanup and recovery efforts. So there are a lot of different components of that $20 billion.